On August 12, 2026, a baby boy was born in Texas. His name is Gabriel, and before he had taken his first breath, his life had already become the center of a legal battle involving surrogacy, abortion, parental rights, medical care, and 2 states with very different laws. But Gabriel didn't know any of that. He was simply a newborn baby. And while doctors prepared him for the medical care he desperately needed, lawyers were still fighting over what should happen to him. Because months earlier, before Gabriel was born, the people who had intended to become his parents had asked for something that his surrogate refused to do. They wanted the pregnancy terminated after doctors discovered that Gabriel had a serious heart condition. She said no, and that one word changed everything. Her name is Mckenna West. West is an Alaska-based nurse and mother of 2 who agreed to become a gestational surrogate for a California couple. The arrangement was supposed to be straightforward. The couple wanted a child. West would carry the pregnancy. The baby would be theirs, and everyone would move forward with their lives after the baby was born. But pregnancy doesn't always follow the plans written on paper. In April 2026, during an anatomy scan at around 20 weeks, doctors discovered something deeply concerning about the baby's heart. The condition was called Hypoplastic left heart syndrome, HLHS. It is a serious congenital heart defect in which the left side of a baby's heart is severely underdeveloped. A child born with the condition can require major medical intervention shortly after birth. The diagnosis changed the future that everyone had imagined. For the intended parents, the news was devastating. They had wanted a child. They had gone through the complicated process of surrogacy because they desperately wanted to become parents. But now they were being told that the child they had been waiting for could face multiple surgeries and a lifetime of medical uncertainty. According to court documents and reporting on the case, the intended parents asked West to terminate the pregnancy. Their surrogacy agreement reportedly contained provisions concerning abortion in cases involving fetal abnormalities. From their perspective, they believed they were making a decision about what they thought would be the least painful future for their child. But West saw the situation differently. She refused. And that refusal created a collision between a contract and a human being. The intended parents believed the agreement gave them rights concerning the pregnancy. West believed that signing a contract did not give someone else the power to force her to undergo a medical procedure against her will. And underneath all the legal language was a question that no contract could make simple. Who gets to decide? The woman carrying the pregnancy, the biological parents, the doctors, the courts, or some combination of all 4? The disagreement escalated. According to reporting based on court filings, West was threatened with a lawsuit seeking $250,000. The pressure became increasingly difficult to ignore. Doctors in Alaska reportedly would not perform the requested late-term abortion, and the intended parents wanted West to travel to California for the abortion. West refused. Then she made a decision that would take the case from a private dispute and turn it into a multi-state legal battle. She left Alaska and fled to Texas. Not because Texas was where the pregnancy had begun, not because the intended parents lived there, but because she believed Texas could provide a place where Gabriel could be born and receive the specialized medical care he might need. That decision placed her directly in the middle of a conflict between state laws, a surrogacy agreement, and competing claims about who had authority over the child. And suddenly, the road ahead was no longer just about pregnancy. It was about jurisdiction. It was about custody. It was about medical decision-making. and it was about whether a contract could determine what happened to a baby with a serious medical condition. Then the office of Texas Attorney General Ken Paxton became involved. Paxton's office intervened on behalf of protecting the unborn child's access to medical treatment. His position was that Gabriel should receive medically necessary care after birth, and Texas sought court protection. The case reached a Texas court. The court issued an emergency order. It was not a final decision about custody. It did not settle every question surrounding the surrogacy agreement, but it did something extremely important. It required that Gabriel receive life-sustaining medical treatment if he was born. It also restricted his removal from the hospital and from Texas while the legal proceedings continued. For West, the order meant that the immediate question of whether Gabriel would be allowed to receive the treatment his doctors believed he needed had been answered.
For the moment. But the larger battle was still ahead, because the intended parents were still fighting for their parental rights. And they still believed they had a legal claim to make decisions concerning their biological child. This is where the story becomes much more complicated than a simple battle between good people and bad people. Because the intended parents are not simply characters in a political argument. They are people who wanted a child. They had dreams, they had hopes, they had gone through a difficult journey to become parents, and then they were confronted with a diagnosis that could change their child's entire life. HLHS can require a series of major medical procedures. There can be prolonged hospital stays. There can be complications. There can be uncertainty. And even when treatment is available, doctors cannot promise a particular outcome for an individual child. That uncertainty is important because the intended parents were not deciding whether they wanted a healthy baby or no baby at all. They were confronting the possibility of raising a child whose life could involve long hospital stays, repeated surgeries, medical monitoring, serious risks, and huge financial burdens. They believed termination of the pregnancy was a humane decision. West believed the baby should be given an opportunity to live. Two very different beliefs. One pregnancy, one unborn child, and no easy answer. But while lawyers argued about what the contract meant, Gabriel continued to grow in West's belly. Every day that passed brought West closer to delivery, and closer to the moment when the legal arguments would collide with realities. Because before Gabriel was born, the case could still be discussed in terms of contracts, clauses, rights, and intentions. But once he entered the world, he would no longer be an idea on a medical scan. He would be a child, a person, a living being with inherent, inalienable rights to life. A child who needed treatment, a child who needed doctors, a child that needed protection, a child who could not speak for himself. And that changed the emotional weight of everything. Then came August. West's pregnancy had reached the point where everyone was waiting. The legal case was still unresolved. The medical situation was still serious, and the baby was still inside her. Then, on August 12th, Gabriel was born in Texas, United States of America. The child whose future had been debated in court had finally arrived. But there was no simple happy ending. Gabriel was born with the heart condition that had started the entire conflict. He needed specialized care, and he was taken into the neonatal intensive care system. While doctors focused on keeping him stable and preparing for the next stage of treatment, the legal battle continued outside the hospital. That contrast is almost impossible to ignore. Inside the hospital, doctors were focused on a tiny human life. Outside, attorneys were still arguing about who the legal authority to decide what happens next. Gabriel has no say in what happens to him. He lacks that capacity. A Texas court had already ordered that Gabriel receive life-sustaining treatment. But custody remained unresolved. The parents had already secured a court order, forbidding the surrogate mother from coming anywhere near baby Gabriel once he was born. The biological parents still wanted their rights recognized. West remained at the center of the dispute, and Texas remained involved. The next question was no longer simply whether Gabriel should be born. He had been born. Now the question was, what happens to him and who decides? The medical team was preparing for the heart surgery that his condition could require. For a baby with HLHS, treatment can involve major stage procedures beginning shortly after birth. The first operation is only the beginning of a long medical journey. And that means the legal battle cannot simply disappear after delivery. The decisions made now could affect Gabriel not just for days or weeks, but for years. That is what makes this case so unusual. The intended parents say they are his biological parents. West says she is fighting to make sure he receives the medical care she believes he needs. Texas says the child must receive life-sustaining treatment. And the courts have to determine how these competing claims fit together. There is also another question that may be uncomfortable for many people. What exactly does a surrogacy contract mean when circumstances change dramatically? When West signed the agreement, she knew she was entering a legal relationship with intended parents, but neither side could know exactly what the future medical situation would be. A contract can describe obligations, but can a contract completely resolve a moral crisis? Can it answer what should happen when a fetus is diagnosed with a serious condition? Can it determine who has authority over medical care? And what happens when the laws of different states point in different directions? Those questions are now at the heart of Gabriel's case, and they are bigger than one baby. They reach into the future of surrogacy itself, because if a contract says one thing, but a surrogate refuses to follow it, what should the courts do? Should the contract control what happens to the baby? Should the surrogate mother lose her bodily autonomy? What happens to my body, my choice? Should a woman's bodily autonomy determine what happens to the pregnancy? Should biological parenthood control what happens to the pregnancy? Should the child's best interests be the principal concerns? And who decides what those best interests actually are? There is another reason this case has captured so much attention. It sits directly at the intersection of three of America's most divisive issues: abortion, parenthood, and reproductive technology. Surrogacy has always created complicated questions about parenthood. For Gabriel, he is just a newborn facing the first great challenge of his life. Gabriel doesn't know anything about any surrogacy contract. He doesn't know about any laws. He doesn't even know the world he has just entered. And for now, the world is asking Gabriel to fight on, and fight he will. As for the intended parents that wanted the baby aborted for having an imperfect heart, and now claiming parental rights over the child, now that he's born, what will they tell Gabriel if he survives and grows to become a healthy adult? Many have called the surrogate mother derogatory names for breaching the terms of the surrogacy contract she entered into with the biological parents. What do you think about this story? What do you think about the roles the Office of Attorney General of Texas played in the whole saga?